Good evening, everyone. Good evening, good evening, good evening. I am Christian McCray Stewart, the founding attorney of McCray Stewart and Associates. We are your trusted advocates for justice and peace of mind, and we are here for yet another Wise Counsel Wednesday. As we are giving everybody a few seconds to come and join the live. Once you have joined, go ahead and like, share, and get the news out that the live has started so that people can come with their questions and receive the answers that they need. But I'm hoping everybody has had an amazing day so far. And as we join on, let's just go ahead and like and share. I'm going to do what I'm asking you all to do as well. Let us like and share. We have a good topic for today and some questions that have already come in. So hopefully we'll have a good discussion. I don't know if it will take us the whole hour, but we are here. Good evening, everybody. I'm just taking the time to share as well to let people know that the live has started. Make sure that we're getting everything out in the midst of the algorithm. Good evening, everyone. All right. And two, as you're joining on, let us know where you're joining in from. I would love to know where everyone is from. Of course, we practice in Mississippi, Texas, and Georgia. However, when we do the Wise Counsel Wednesdays, we provide very general advice, right? So that way anybody can actually join on. And so we would like to know where you're joining us from. All right, I have done my part and I have shared. Good evening, good evening. I see some people joining on. I see people liking and sharing the live. So we thank you. We thank you. We thank you. Hope everybody is doing amazing today. You're doing amazing. Glad that you joined us on this day. And without further ado, we want to be respectful of everybody's time. I know we've all kind of been working and we have things to do, but hopefully we'll have an amazing session. You get your questions answered, you'll walk away with some wisdom and knowledge, because as we all know, that knowledge is power and people perish for a lack of knowledge. So we want to come and answer these questions you have so that you're able to navigate your legal issues and at least be aware of what may be the next steps for you. All right. Disclaimer: answering your questions does not form a attorney-client relationship. If you have further questions and we can be of further assistance, we'll have a QR code at the end. You can scan that to get all of our information. Also, as you'll see, the better at the bottom, please follow us on all our social media platforms. We're always putting out information to be helpful and beneficial to our past, present, and future clients. All right. Okay, so let's jump into it. Our topic for this evening is going to be mediated settlement agreement. Mediated settlement agreements. And what happens with these are agreements. So if you have like family law cases, personal injury cases, even probate cases, there is a time where you go to mediation and that you're able to reach an agreement. Right. And so we're going to be discussing what these are, what they look like, how they can be enforced, just all the questions that have already come in at any point of time. Do not hesitate to drop your question into the chat. All right. Drop that question into the chat and we'll make sure that it's addressed. So let us go ahead and get our live Q&A going. So I will remove that and let us get right into it. All right. And as you're joining, like and share. Let us know where you're joining in from. Type your question into the chat. But let's get started with some of the questions that have already been submitted. So what is a mediated settlement agreement? I actually answered this question as soon as we were starting, but it's basically where the parties to a suit, they go and they have a neutral party who is referred to as the mediator, and they address all the issues, all the claims of that suit for the parties to reach an agreement, right? And then once the parties have agreed on some of the terms, all of the terms, it is then produced or documented in what is referred to as a MSA, and it annotates the parties' understanding of what they have agreed to, right? And so basically that's what a mediated settlement agreement is, something that you do prior to actually going to trial and presenting your case to the court or to a jury, and you're able to control the outcome of the case, if you will. Is a mediated settlement agreement legally binding? Yes. And there is actually language inside the MSAs, and I'll say MSAs, it's the mediated settlement agreement. We're just using acronyms, but there's language inside the mediated, inside the MSAs is basically saying, look, the parties understand that basically, like, this is legally binding. They have read everything, they understand everything, and that they're agreeing to it, right? Because if you fail to agree to it, there are repercussions or there are courses of actions that the other party can take if you fail to abide by your agreement in the MSA. How is an MSA different from a court judgment or order? So, and this is a wonderful question. Typically, what happens with the MSA is that it actually becomes a part of the final judgment or the order, right? So I'll give you an example. We have a family law case. We went to mediation. We've got an agreement on all the issues dealing with child custody, child support, visitation, other aspects of property division, except for the marital home. Well, what happens in that document is all those things are annotated, right? And so before it's actually become a final order, there's not much the parties can, do. But when it's effectuated into an order, the judge actually signs off on it, then that's when it becomes enforceable. So it is legally binding, but there's sometimes it's separate from the final judgment or order until it's actually incorporated and you have a judge sign off on it. Okay. And as we are answering questions from the answers, if you have additional questions, please go ahead and type those in the chat. Okay. And so what happens if one party breaches the MSA? Great question. We actually had this come up. We had a virtual hearing wrapping up a case yesterday, and this was an issue. The MSA had been agreed to by the parties a couple months ago. We were set for trial dealing with one issue that eventually got resolved. But while we were before the court, we asked the judge to do what is referred to as an admonishment. And this was basically to say, okay, judge, the parties have agreed to these terms. However, there are various aspects that both sides are not complying with. Will you admonish them, Your Honor, on what this looks like should they continue to not stand up to their part of the agreement? And basically, what the judge explains is that, look, when I sign off on this MSA, when it becomes a final judgment, if you fail to comply with it, an enforcement action can be filed with the court. And basically that's action that you're going to the court to say, judge, this person is not fulfilling their obligations. They're not fulfilling their responsibilities as it relates to the order. They're not doing X, Y, and Z. And then they have to come before the judge to discuss why they are not complying with an order from the judge. And then depending on what circumstance or situation that you're dealing with, the various repercussions or consequences will vary. Let me give an example. So say, for instance, this is one that comes up a lot in family law cases. It's dealing with child support, right? So, well, judge can order that you're in jail for some time. You have attorney's fees that could be ordered. Of course, you're going to be ordered to pay your child support, but that may change. The monthly amount that you're paying and things of that nature may change. So there's various tools or various things that a judge can impose should an individual be found to be in violation of their MSA, which has now become a final order with the court. So trust that in all this that's going on, you're not, in litigation or filing suits. And it's like, oh, let's go to mediation. You come to an agreement, and then the individual can just walk away and say, oh, well, I'm not going to, fulfill my obligation. That is not the case. Because in most cases, majority of cases these days, even years ago, most cases do resolve themselves. Personal injury cases, family law cases, any suit that you're filing, a good majority of those, they resolve themselves in one fashion or another. Can an MSA be modified after it's signed? Only if by agreement of the parties. Like, one person can't unilaterally change the terms of an MSA. And typically, if that happens, what you see is that maybe, there can be adjustments that's made prior to it becoming a final order. But ultimately, I think the simple answer to that, if there's a mutual agreement between the parties. Also, if you by chance there happened to be something where something wasn't documented correctly and there's an error, you may see that happen, but typically it's going to be by mutual agreement of the parties. Do we have to go to court after signing an MSA? Not necessarily. Of course, this depends. Remember, I was sharing that sometimes what happens with your MSA is typically it'll become a final order. If you all resolve all of your issues, then sometimes what can happen is that the attorneys will get together and they'll have it incorporated in a final order. All the parties will sign off on it and it's submitted to the court. However, if in your mediation, you've only resolved some of your issues and not all of them, then you're going to have an additional court date. But for the most part, when you're going to mediation, the goal is always to get everything resolved. And should you accomplish that, amazing, because then what happens, you're not going to have to worry about going to court. You will just get that final order submitted to the judge for them to sign off on it. And I'm pretty sure I've seen a question in regards to this. Will the judge automatically approve our MSA? I have yet to see, let me say it this way. I have yet to see a situation where the judge doesn't agree to an MSA. If for some reason something comes up where there seems to be maybe somebody has not voluntarily signed it, you may potentially have issues there. Or if you have a situation where children are involved and the judge is looking at it just like, well, this is not in the best interest, you could have a situation where the judge is not approving it when it gets to the final order stage. But I have yet to see that. For the most part, if the parties have a mutual agreement, there's a meeting of the minds, the court will honor it. What should someone do before signing an MSA? Read it thoroughly. Make sure that you understand everything that is in there. Do not be rushed to sign anything. And 9 times out of 10, what happens is once you have your mediation, the MSA is produced and is provided to both parties right then and there. Don't feel rushed. If you need additional time, take the additional time that you need. Because if there is something, you're executing a document to say, look, I've read everything. I've understood everything. I agree to everything that is in here. So you want to make sure that you understand that. If you have questions that you have asked them, you've received the clarity that you need prior to executing that document. That is a wonderful question. And that's with anything that you're doing today. It's so easy. Even with our phones, we get updates and they're like, oh, this agreement and all these different things. And you just you skim through it real quick and then you sign off on it. These MSAs, any documents, read it thoroughly before you put your John Hancock on it. How do I enforce an MSA if the other party doesn't comply? I touched on this a little bit earlier on. You're basically going to file an enforcement action with the court, basically saying, Judge, this person has failed to comply with X, Y, and Z terms. I need you to step in, figure out why they didn't do it, and enforce them to take action. We have a question. Are there situations where a court might set aside an MSA? If you have a situation I kind of briefly mentioned this. If you have a situation where it's come to the court's attention that somebody has been threatened, coerced, that they didn't do it voluntarily, then you will find yourself in a situation where the court will entertain setting it aside. But it's in those situations. Beyond that, the courts are saying, look, it's a meeting of the minds, unless it's something absurd, which you typically do not see. No, but if there comes an instance where the judge thinks there's been some type of foul play, then you're potentially in a situation where the court may set it aside. Can I revoke my agreement after mediation? No, you cannot. And let me say this. Unless, with a caveat, unless there's supposed to be like some like you do in order for this to take place, right? So if somebody was supposed to perform some type of action for you to then act, then you can have a justification of why you're not performing. But simply to say, well, I agreed to this, now I don't like it, I want to revoke it, that is not the situation that you want to find yourself in. That is one of those where the other party is then saying, okay, this individual is failing to comply with the terms of this agreement. Now let me go back and get the court's assistance to enforce them to take the necessary action. Oh, and so we had a question, and I've kind of mentioned this, and this is what the question we had here was like, are there situations where a court may set aside an MSA? One of the questions we received was, what if I was pressured or coerced into signing the MSA? Then that needs to be brought to the judge's attention. If you have counsel, hopefully that is not the case. However, I do know that there are a lot of situations, a lot of cases where individuals represent themselves pro se. I have yet to hear or come across a case where an individual was coerced or pressured into signing the MSA, but that's not to say that something cannot happen of that nature, right? Should that happen, you definitely want to bring it to the court's attention. If you're having trouble doing that on your own, then you want to seek counsel to assist you with that, because that should not happen. These MSAs should be entered into by all parties freely and voluntarily, right? Now we'll say this. Enter into an MSA doesn't mean that you've gotten everything that you wanted, right? And it feels good. Typically, when you're in mediation, it's give and take. Both sides are giving a little something, giving a little more than they would want to, and accepting a little less, right? But that's the part of the MSA. That's a part of the mediation and what it's trying to produce. It's trying to get to a place that is just like, hey, you control it. You don't necessarily get to a place where you're taking this before, as I stated, the judge or the court, and you don't know what's going to happen. You kind of control the outcome of it. But I will tell you, it's not one where you see a lot of cases and people come out, it's like, yes, I got everything that I wanted. No, there's a little give and take in these situations. Okay, and so we have some questions that come in specifically dealing with family law and MSAs. So I will definitely address those. And as you're joining on, if you have a question, any question at all, or a question that comes up as a question is answered, please make sure that you go ahead and drop it in the chat, okay? Can custody and visitation agreements be included in the MSA? Yes, they can. They surely can. We actually just had one on a divorce proceeding, on a divorce that was filed. We entered into an MSA back in April. So yes, you definitely can have those type of agreements included in an MSA. Does the MSA become part of the final divorce decree? It does. It does. So kind of as we've been discussing, what happens is that the MSAs are incorporated in the final order, right? So what happens is you file a suit, and typically most Texas courts encourage, it's part of your scheduling order, that the parties are going to go to mediation, right? To see if you can resolve this without the expense of trial, because trial can be expensive. But in the midst of it, the parties reach their agreement. Then what happens is their agreement, if you will, becomes a part of the final order. The MSA is presented to the court to say, look, judge, they resolved all the issues, or they resolved some. There may be some still lingering, but this is outlines what the parties have agreed to. And you want to know what's the good part? The point of that as well, to do it, to get it annotated or documented in the MSA. So you don't have those instances where people come back and say, well, no, I didn't agree to this, or no, I don't agree to those terms. They have that official document that say that it's legally binding, that all the parties have signed off on, saying, look, this is my agreement. Okay. And so those are presented to the court or filed with the court. And then it becomes, it becomes a part of the final order. How does an MSA affect child support and spousal support? It varies. And the reason I provide that answer is because it's based on the terms that the parties agree to, right? In a divorce case, you can agree that there's going to be no spousal support, right? Typically in most states, you have child support guidelines. Well, guess what? The parties can agree to no child support. They can agree to an amount of support that is less than the guidelines. In some situations, for various reasons, you could agree to an amount that's above the guidelines. So the effect is not necessarily negative or positive, if you will. It's what the parties have agreed upon. Okay. And it can touch on those areas of your divorce. Can the MSA include parenting plans and schedules? Yeah, I think this kind of relates back to the question about custody and visitation. Yes, it can. Yes, it can. You will definitely address those matters, because basically what you're doing, you're addressing all the issues that will come up in your suit to try to see if you can reach a resolution. So if you have a couple who's been married and they have children, well, you can deal with the children. You can deal with their custody, their visitation, the parenting schedule. You can deal with child support. You can deal with insurance. You can deal with all those aspects, right? Say that you have various retirement accounts, investment properties, marital home, all those different things. You can address all of those issues. Potentially, you can agree to all of them. Also, there's many cases, many scenarios where it's like, look, we can agree to all these different things, but this issue is outstanding. And then that can be an issue that's litigated to the court. What if circumstances change after the MSA is signed? And they reference like income or relocation. So in these instances, and we're addressing these, remember, in the family law context, these are going to be situations where either you and the other party needs to talk and see if you all can reach an agreement. Because the thing about it is, if you can reach an agreement and it's outside what your MSA says, you all can do that. However, if it's a situation where it's not possible, then you're going to be in a situation where you're potentially going back to the court to seek some type of modification, right? So say, for instance, if you are the parent who has been ordered, or you agreed to pay child support in X amount of dollars, but your income has been reduced for any reason, right? If you can get an agreement with the other parent to say, okay, let us reduce this amount to X, Y, and Z. And in that instance, you want to get it in writing and get it submitted to the court, just because typically those payments are submitted to the AG's office. But either way, what you want to do is file for a modification. And that way you can get an official order from the court, should they grant it, saying that your child support is going to be reduced. Or say that they're typically, when it comes down to relocation, we try to be mindful. And when we do the final order incorporating the MSA, have language about the distance. Like, okay, now should they be 100 miles or more apart? Well, this is what the schedule should look like, to prevent people from having to continuously go back before court when life changes happen. But in those situations, if you have something that occurs, you can't get an agreement, the circumstances have changed, then you're just going back to the court for a modification. And it's not, having that initial agreement doesn't hinder you from going to seek a modification. And so if some people have been on the live, or you come back and you watch the replay, and we've had discussions about, child custody modification and all those different things, just know that the fact that you have an MSA in place, or you had a mediated settlement agreement, does not hinder your modification. But it will be something that does come up, because the judge is going to be trying to see, okay, what's going on here? Is this something that you all agreed to? And is there a valid, justifiable legal basis for that judge to come in and disrupt what you had initially agreed to? All right. Okay, now we have some questions specifically dealing with the MSA, the Mediated Settlement Agreement, as it relates to business and civil disputes. Can we use an MSA to settle a business contract dispute? Yes, you can. Mediation can be used in various civil litigated matters. It can. And it's beneficial. It is a helpful, mediation is good. Mediation can be, it can be productive. Let me say that. It can be good in some situations. In some situations, mediation just doesn't work and you just have to have your day in court, which is also totally 100% fine. Is an MSA confidential in business litigation? Unless there's some agreement between the parties for it to be sealed that's been presented to the court, typically not. In most cases, besides family law cases, it's public record, right? When you have family matters, family law matters, the courts automatically kind of seal those records. And if you're not an attorney or a party, you don't get access to those. What kind of terms can be included in a civil MSA? This is a very broad question. And the reason is because it really depends on what you're litigating, right? When you talk about a civil MSA, this can be a breach of contract. This can be, some type of tort that's taking place. What I will take, so for example, you do have situations where individuals are suing another party and they may have like confidentiality agreements and things of that nature that are in place. And so those are like some terms you can agree to, but it's very broad. And so what I will say is this is the terms that you have in your civil MSA, it depends on the type of case that you're litigating and then what you and the other party agree to. What you and the other party can, you can be as detailed as possible. You can limit what you put in there. But you're basically addressing the issues that have become a part of the lawsuit. Is an MSA enforceable in a different state or jurisdiction? Yes, for instance, it's funny when we have certain topics that we come and discuss on Wednesdays, it's like a certain particular area of the law. It's easy to be able to discuss a certain example and answering the questions. So if you have a MSA being enforceable in a different state or jurisdiction, when you think about family law cases, right? Because we have there's the federal laws that allows parents to travel to other jurisdictions, and those jurisdictions enforce, previous orders. And so in this instance, say you had an MSA that becomes a final order, and for whatever reason, now this parent is traveling to a different state, and they're going to register that court order there, and something happens, and everything from a procedural standpoint is in place, they can bring an enforcement action there. So yes, you can. Okay, and 30 minutes in, it looks like we're getting to, I have one last question here, so I will go ahead and throw this out to the group. If you happen to have additional questions, go ahead and throw those into the chat, type it into the chat so we can make sure that we address your question. It says, how do I make sure the terms of the MSA are fair and protect my interests? So, of course, this is where, like I say, some people decide to represent themselves pro se. Most people who have their attorneys in the process of them doing the mediation, they're able to inquire of their attorney about different aspects of what's going on. Okay, well, they came and presented this from what the law requires, from your experience, for the facts and circumstances of this case. Does that seem just? Does that seem fair to you? And then they can have these discussions back and forth. So typically what happens, that's what happens in mediation, right? We had one here recently in a personal injury case. So you have us in one room, you have the other party in another room, and you have the mediator who's going back and forth and saying, okay, this is the offer. This is where they are as far as where they're going to settle at. And so we're going back and we're addressing all the aspects of the personal injury case and the injuries, the damages, what it looks like in a litigation, what potential outcomes would you have if you're dealing with a jury, all those different things. We are exploring and having those discussions to get to a point of making a decision or a determination of whether or not that potential settlement is going to be fair and is protecting the interests of that particular client. And so that's the thing, how you're sure it's like typically you have counsel there who's able to give you guidance from their experience based on the law and your particular facts. And I always kind of mention this, I think on majority of all the lives, every case is different, right? So your outcome, what you're looking at is going to vary. Sometimes people are, I won't say misinformed, but their expectations sometimes are not realistic in certain situations because they've heard of somebody's circumstance and this was the outcome. Then they think, oh, that should be the outcome in their case. And it's like, well, no, the facts and circumstances are truly going to play a part in the outcome, right? And as we know, every case is different. Every case is different. So that is definitely something to keep in mind and something that we as counsel try to advise our clients and give them as much insight and guidance as we can, right? But yeah, so that's the discussion far as mediated settlement agreements are concerned. Like I say, mediation is a great tool in resolving cases and limiting the exposure and expense to the clients in various situations. But as also stated, sometimes it's just like, look, no, I have to have my day in court, which is also 100% fine. So I don't see any other questions that are coming up in the chat, but I will continue to monitor those. What I do want to share with you is if you have any additional questions, there's anything that you want to discuss, whether it's on this topic or any legal issue at all, scan that QR code. You can go ahead and schedule a time to speak with us for us to consult and dig deeper into your legal issue. As I stated, when I say all cases are different, they're different. So the information we provide on our Wise Counsel Wednesdays is meant to be very general, to give you some guidance, or just to get you knowledgeable. Should you ever find yourself in a situation, you're like, hey, I remember I was on that live and I was able to get this information. I know what this is. Or somebody comes and shares something with you. You're able to give them some insight or potentially refer them and say, hey, I think this is a firm that would be able to assist you should you have some legal questions. Okay, so you can scan that QR code and get all of our information. Also, I want to invite you all to join us at the induction gala. I am the 2025-2026 board member, as well as the public policy co-chair for NABO. It's the National Association of Women Business Owners here in the DFW. And so the new board members, as we come on, there will be a induction taking place June 26, 2025 at 6 p.m. And it's going to take place at the Tower Club. You can scan that QR code, early bird tickets, and on Friday, midnight, 11:59. So if you are interested to come and celebrate, I mean, and beyond seeing the board members who are going to be inducted this year, it is a great opportunity to network and to meet like-minded business women. It'll be an amazing opportunity for you to get out. Also, good music, good food. You don't want to miss it. So we invite you to come and join us for the induction gala. Also, I will be speaking at the Attract Abundance Conference, October 24th through the 26th. If you want to go ahead and get your ticket, you can use that discount code Christian10 to get your discount. This is going to be an amazing opportunity just to be filled with information and knowledge that is going to help you grow, to attract abundance, to build wealth and generate wealth, not only for yourself, but the generations to come. It'll be an amazing time. And so we would love for you to be able to join us there. If you haven't already, please follow us on all our social media platforms. As I tell you all, we're always putting out information. We want to come and bring you knowledge, bring you insight, bring you information that's going to be helpful and beneficial to you. As we continue to come on here to do the Wise Counsel Wednesdays, I encourage you all, if there's any legal topic, any legal area that you have questions, share those with us. Send us a DM, send us an email. Let us know, because we want to come and bring information that's going to be helpful for you. All right. McCray Stewart and Associates. We are your trusted advocates for justice and peace of mind. I'm so glad for everybody who was able to join this evening. You all continue to have an amazing day. Until we meet next time, you all have a great one.